You guys ready? Excellent.
Before we start, I'm going to want to see a status on our rate.
Okay. I think we just ended the echo. Let me make sure Ms. Clay is ready to go. Ms. Clay, can you hear us?
Not hear the state.
Their microphone, is it a red light or a green light on your microphone, Ms. Collier? Right in front of you.
It is, so it's now green.
Now it's green. Excellent. All right, Ms. Hankins, your microphone is green.
Yes, Your Honor. Can you hear me?
All right, Ms. Clay is ready. Let's go on the record, please. This is the revocation hearing for Roderick Jones. We're going to get him into court in just a moment. It is a whole series of cases. I'll just list one of them, 15 SC 132672. We've got 1, 2, 3, 4, 5 burglaries for which Mr. Jones is on probation. And unfortunately for Mr. Jones, there is a new allegation of a shooting. It's a 22 CP 207682, and that's the primary basis for the petitions to revoke Mr. Jones's probation in the 5 open cases. This hearing's been set for a while, and we've got Ms. Collier and Ms. Clark. Hello, Ms. Clark, here for the state. Ms. Hankins for Mr. Jones. Anything we need to talk about, Mrs. Collier, before we bring Mr. Jones out?
Yes, Your Honor. The victim in this case, Mr. Thomas Cook, was going to appear via Zoom. We've already spoken to the defense about that. Unfortunately, he has been arrested. So he's in Henry County. I've also spoken to the defense about that. The reason why I have not set up for him to appear via Zoom for the Henry County case is because I have not been able to obtain who his defense attorney is for that particular case. I was given the name of a firm because I was advised that in Henry County, it's not the public defender's office that represents them. In fact, it's a firm, but I have not been able to speak to anyone at that firm because it just happened. In fact, he just had his first appearance yesterday for that particular case. He has a $7,500 bond. And I was even advised by the mom that he very well may make that bond, but the problem would still exist where I would not talk to him without reaching out to that defense attorney first. And so that's where we stand as it relates to the victim. We do have the other 2 witnesses present, and I wanted to get the court's direction as it relates to either going forward with these 2 witnesses. I've spoken to the defense about her posture, and she does not have an objection one way or the other as it relates to how we proceed. And so I wanted to get direction from Your Honor.
Okay, thank you for that update. not an expected development for you. Mr. Cook was arrested for what?
He was arrested for, and this is not per the information that I've been able to see, this is per his mom, but he was arrested for a gun charge as well as marijuana possession.
Okay. A gun charge as in a possession charge, a status offense, or a gun charge as in he shot at an officer or he shot at someone? Or mom just said gun charge?
The mom said gun charges and possession charges because she said weed.
Okay.
And the bond was $7,500. So maybe that can give you some indication that I do not believe that it involved any type of aggravated assault.
Got it. Okay.
And all of this is per the mom. I have not laid eyes on any of this information.
Okay. Well, thank you for that update. Ms. Hankins, we'll get Mr. Jones out here in just a second. My inclination would be to go forward with the two witnesses who are here. Mrs. Collier and I have a history of having revocation hearings that span over multiple hearings with your predecessor. And well, actually, it's not your predecessor, it's a private attorney, but it was a guy who was in drug court and he's had other issues. I don't want to prolong this for Mr. Jones, but I in particular don't want to make these folks have to come back if they're here. And so my thought would be we take the testimony from the two witnesses who are here and then we either say we need to wait for Mr. Cook or we may not need to. I may find probable cause just from hearing from these two. I'll hear from you if you think hearing from Mr. Cook, in other words, a cross-examination of Mr. Cook, if it is a witness you wanted to cross, but it would be a state's witness, might change that balance. I don't know the facts at all, but hypothetically, if the officer's going to say, here's a video that I retrieved from the gas station and it's very clearly Mr. Jones shooting Mr. Cook, I don't know that I need Mr. Cook because of the standard of proof. But at a minimum, setting all that aside, I'd prefer to take the testimony from these two witnesses, let them be on their way, and then we'll discuss with your client present the necessity of getting Mr. Cook here virtually or in person and how quickly we can do that. Does that work for you?
Yes, Judge.
Great.
One last matter, Judge, speaking of video, I've spoken to the defense about the video and the defense has no objection to us playing the video. And this was even before there was any type of issue. We were just going to play the video.
The video is what? There is surveillance video?
We do have surveillance.
Okay. And how long is it ballpark?
Oh, it's 2 minutes.
Okay, great. Okay, let's bring Mr. Jones out, please, and get him up to speed, and then we can get started.
It gets feedback. Take a look. The judge know about the feedback.
Your Honor, one thing I did turn my, it's regarding the sound. So on my system, whenever I turn off the sound, it takes the feedback. But when I noticed that whenever the sound is on, that's when the feedback is.
You don't need sound on your computer.
Okay.
I'm assuming the surveillance video is video only, not audio.
Yes.
So you should have the sound off on your computer and then we won't have any feedback.
Gotcha. Okay.
Thanks.
Morning, Mr. Jones.
All right, let's get started. Good morning, Mr. Jones.
Good morning, Mr. McBurney.
How are you?
I'm okay.
I guess all things considered, that's not a great question, but you're here, you're healthy at least. Mr. Jones, this morning is when we will start. We may not finish because of development. I'll share with you in just a minute if Ms. Hankins hasn't had a chance to update you, but we're going to start the revocation hearing. It is alleged in probation warrants for each of your 5 cases that you violated your probation in 2 separate ways. One, that you committed the crime of aggravated assault and possession of a firearm during commission of a felony in March of this year when you allegedly shot a Mr. Cook. And we've talked about this before. We had an initial conversation about it. You also supposedly owe $55. I'm not particularly worried about $55. I'm pretty focused on these new allegations because they're very different from the cases you and I worked on, your series of burglaries that got you initially into accountability court and then ultimately into a different situation. So this is a new breed of allegation. Your lawyer on your behalf has denied the allegation, meaning the state needs to try to prove, if it can, by a preponderance of the evidence. So in a revocation hearing, it's not like a trial where the state has to prove beyond a reasonable doubt. Preponderance is, if you think of the scales, if I find that the state's evidence is a little stronger than the defense evidence, if there's any defense evidence, I need to rule in favor of the state. If I think it's equal, or the evidence is stronger for you, then I reject the allegations and say the state has not met its burden. I learned this morning that Mr. Cook is not available. He is someone that the state was thinking about calling to testify, but he can't connect with us today. So what we're going to do is hear from two other witnesses. When we're done with that, those witnesses can be on their way. And then your lawyer and you and I and the prosecutors will talk a little bit about whether I've heard enough evidence to decide whether the state has met its burden, or if we need to have part two of this hearing and figure out a way to get Mr. Cook here. Do you have any questions about the process that I just described?
No, sir.
Okay. Ms. Clark, will you be handling the witnesses or will Mrs. Collier?
I will, Your Honor.
Great. Well, why don't you call your first witness?
The state calls Detective Demetrius Campbell.
Okay.
Good morning. My name is Demetrius Campbell. That's Demetrius. Last name Campbell, Campbell.
And for everyone's understanding, if you're doing some talking, you're either asking questions or you're responding to questions. If you don't mind having your mask off, it makes it a whole lot easier for Ms. Clay to hear you all. If you're not comfortable with that, I respect your health choice, but otherwise, masks down when you're talking would be great. All right. When you're ready, Ms. Clark.
Good morning, Sergeant Campbell. How are you?
Good morning. I'm well. Thank you.
What is your occupation and profession?
Right now, I'm a sergeant with the City of Atlanta Police Department, Zone 4.
Okay. And how long have you been employed with Atlanta PD?
Since July of 2013.
And at the what are your present duties?
Presently, I'm a patrol supervisor. I work overnight in Southwest Atlanta.
Okay. In March of 2020, what were your duties at that time?
I was a detective assigned to the aggravated assault unit.
Okay. And were you employed in that capacity on March 5th, 2022?
Yes.
Okay. And were you called to the 2500 Center Street?
Yes, I was assigned to that case.
Okay. And is that in Fulton County?
Yes.
What date did you become involved with this investigation?
It was March 6th, I believe.
Okay. And how were you brought into the case?
Well, the incident happened on March 5th, to my understanding. And the aggravated assault unit has different shifts. And at the time of the incident, other investigators responded initially. And the next day, it was determined that the case would be assigned to me.
Okay. And so I want to talk a little bit about your investigation. Could you tell what happened?
Okay. March 5th, the Atlanta Police Zone 1 units were alerted to a person shot. The victim's mother actually attempted to call 911 multiple times, but ultimately ended up transporting him to the Zone 1 precinct. Where
The victim, so this would be Mr. Cook.
Mr. Cook,
His mom transported him to the precinct.
to the precinct, yes, sir.
Okay.
Yes, sir. She said that she had tried to call 911. It was taking too long, so she just wanted to get him some help.
Okay.
So she took him to the precinct, and then he was met at the precinct by Grady and transported down to Grady.
And when you say he was transported, who are you referring to?
The victim, Mr. Thomas Cook.
Okay, continue.
Yeah, so officers were able to locate a crime scene at 2500 Center Street in front of the C building. There was a witness who stated that she saw the shooting and was familiar with the suspect and the
Okay.
victim.
And do you recall the witness's name?
Yes,
Okay,
Alexis Riggins.
okay. And Alexis Riggins, who did she identify as the shooter?
She identified her friend and her sister's, the father of her sister's children, Roderick Jones.
Okay, and is Mr. Jones in the courtroom today?
Yes.
Okay,
What is 2500 Center Street? That's an apartment complex because I'm familiar with that address. Remind me what complex is there?
Rolling Bins, I think that's the new name of
That's
it.
the new, what it used to be called?
Etheridge.
Etheridge.
Etheridge Court. Etheridge Court. Thank you. Okay. Don't answer the questions.
Sorry.
That's okay. Just your lawyer is going to get unhappy with you if you answer the questions. All
okay.
right. Etheridge Court, but now Rolling Benz.
Rolling Bins, yes, sir.
Benz like Bendz or Benz like Mercedes?
BENDS.
DS. Okay.
And you said the defendant is in the courtroom. Could you, for the record, point to him?
Yes.
You just describe what, I mean, pointing is there are a lot of people in the courtroom. What's he wearing?
So he's wearing I believe it's a blue shirt with a gray undershirt, glasses, and a black KN90, a black face mask.
And could you describe his hair?
Yes, his hair is in, it's like short dreadlock style.
Okay. One moment, Your Honor. Let the record reflect that the witness has identified the defendant as the person who shot the victim, Mr. Cook.
So the record should reflect that Sergeant Campbell has identified Mr. Jones as the person that Ms. Riggins identified.
Right.
As far as I haven't heard Sergeant Jones say anything about having seen anything, but you've connected the dots you were trying to connect.
Okay, thank you.
Sure.
And so you spoke with Ms. Riggins, and did she provide any further information?
Yes, the investigators on scene interviewed Ms. Riggins, and Ms. Riggins said that the victim, Mr. Cook.
Your Honor, I would just object to any hearsay.
Okay.
Your Honor, even though the testimony, the officer is not testimony for the truth of the matter asserted, he's basically talking about the steps in the investigation and not to prove, it doesn't go to the defendant's information or identification. It just goes to what was done in the investigation.
Okay. So repeat your question.
Okay.
Or ask another question, but then I'll work with Sergeant Campbell to make sure we aren't getting what Ms. Riggins said, if it might be offered for the truth of the matter asserted.
Okay, I'll rephrase.
Okay.
Sergeant Campbell, what evidence other than the witness's testimony pointed to the defendant?
Well, there was video surveillance of the incident. And along with Ms. Riggins' recorded statements, we were able to use some closed source law enforcement investigative tools like Omnix and our report writing system searches to develop a suspect. And I was able to create a 6-person photo lineup and present that to Mr. Cook.
And the video, how was the video obtained?
The investigators who initially responded to the scene were able to view and record the video surveillance from 2500 Center Street.
Okay. Your Honor, one moment. The state is gonna. Your Honor, this is State's Exhibit 1A.
So before you play more of it, why don't you, it's not in evidence yet, so
Right.
maybe Sergeant Campbell can identify it, lay a foundation, and we'll see if there's any objection
Okay.
to it being admitted and played.
Your Honor, it was stipulated that the video would come in prior.
Oh, you mentioned that when we were talking about how this morning would flow. So Ms. Hankins, number one, you had a chance to review this video, or at least you're familiar with its origin?
Yes, Judge.
Okay, any objection to it being admitted states 1A solely for the purposes of this revocation hearing?
No objection, Judge.
Okay, 1A is admitted. You can keep playing it.
Okay, all right. Sergeant Campbell, could you describe on the record what we're viewing right now, the video?
So yes, this is 2500 Center Street in front of the C building. And Mr. Cook, the victim, is inside. And this is Mr. Jones, they're in the driver's seat of that white vehicle along with his children.
So the guy who had like the black skull cap, all black, who was loading the infant into the white car,
Yes, sir.
you're saying you believe that's Mr. Jones?
Yes, sir.
Okay, with, I guess, mother of his kids, maybe sister of Alexis Riggins.
Yes, sir.
Okay, so that's Alexis Riggins' sister and the kids they share.
Yes, sir.
Okay.
So I'm gonna play it again, Sergeant Campbell, and if while the video is going on, if you could, tell what your investigation.
Yeah, so Ms. Riggins stated that her Mr. Jones came to the apartment and asked if Mr. Cook was there. And he confronted Mr. Cook.
Again, just any hearsay, I would object to.
Sure. So rather than relaying what Ms. Riggins, and it may be that what you know about it is solely from what Ms. Riggins told you, and then we'll need to hear from Ms. Riggins rather than from you. So let's avoid, if you can, Ms. Clark, having Sergeant Campbell recount what Ms. Riggins said as opposed to what he was able to learn from his review of this video.
Sergeant Campbell, so from your review of this video, what were you able to learn?
I was able to learn that Mr. Jones, or the person here in the black skull cap getting to the driver's seat of this white vehicle, had a silver handgun, and it's a little choppy here, but you from the video, which I reviewed, it's the same video, you can actually see him raise it up.
All right.
This would be before or after. A whole bunch of the video seems to be Mr. Jones and Alexis Riggins' sister loading kids into the car. The gun happens, it's already happened, or it's going to happen later?
No, it's going to happen. It's going to happen later.
Okay.
And I'm gonna pause it. Okay. It's not. Okay, I'm gonna go back. One moment, Your Honor, sorry. Okay. I'm paused the video.
You should have it in front of you so you don't have to twist around. If you click stay muted and then got it, there you go.
And so this frame you were referring to the defendant?
Yes. Like I said, the video is kind of choppy here. It's not really, I guess, because it has been converted and downloaded or whatnot. But yeah, you can actually see this person here in this black skull cap and the black shirt and black pants retrieve a silver handgun.
Okay, and Your Honor, may I approach the witness?
Yes.
Okay. Let the record reflect I'm fighting that. Questions about it? One moment, sir. Okay.
Thank you.
Okay, so Sergeant Campbell, I just handed you some photos that are, could you take a look, moment to look at them? And this is State's Exhibit 1 through 4.
So 1A was the video,
Yes.
and this is now 1 through 4, the 4 photos you've just shared.
Yes,
Okay.
Your Honor. Okay. Have you had a moment to review them?
Yes.
Okay. Do you recognize?
Yes, these are photos taken from the video, the shooting.
Okay. And do these photographs fairly and accurately depict the defendant therein on March 5th, 2022?
I would say so. He's wearing glasses that he's currently wearing. I don't know if they're the same exact ones, but
These are still images that were taken from the video we've been watching.
right.
Okay.
All right, Your Honor, people offer State's Exhibit 1 through 4.
Where did you used to work? Have you always been in Fulton County or in another state?
In another state,
Okay.
Mississippi and Texas.
And do they call it people versus in those cases?
Yes, Your Honor.
Okay. You said people, I'm like, hey, you must have practiced in another state.
Yes, Your Honor.
States Exhibits 1 through 4, any objection, Ms. Hankins, to the admission of 1 through 4?
Judge, I would just like to ask the witness a couple questions.
Okay. Do you want to wait till you cross or you want to ask now before I rule on their admissibility?
Whatever is the court's pleasure.
Okay, I'll admit them, but if your questions call into doubt either the authenticity or the foundation of these photos, we can always review that. All right, so state AKA peoples 1 through 4 admitted.
Okay. And did you have an opportunity to how did you utilize the surveillance video?
Well, the surveillance video was just it was just a tool to kind of gain an understanding of what took place. So I listened to interviews that were conducted by other investigators. I listened to interviews from witnesses on scene and interviews from the victim. And then ultimately when I went and spoke to Mr. Cook, I gathered his statement, and the video was just simply used to kind of corroborate what everyone was saying. So the video itself it just confirmed that something did happen there. Using the other interviews that were conducted and the interview that I conducted myself with Mr. Cook, just kind of all tied it in together.
Okay. And where did you interview Mr. Cook?
At Grady Hospital.
Grady Hospital. And what did you observe about Mr. Cook?
Oh, well, he was still suffering from his gunshot wounds. He had multiple to his legs.
That's where the injuries were, to his legs?
Yes, sir.
And
I thought they said his injury was to his feet.
one moment. Your Honor, may I approach?
Yes, ma'am. Thank you.
So the injuries, could you describe the injuries that you observed?
Well, since when I spoke to Mr. Cook, he had been in Grady. He'd been at Grady for a few days, so his injuries were pretty well bandaged up. But these photos would depict where he told that he was injured at.
Objection to hearsay.
Your objection was what?
Objection to hearsay. The statement was where he told his,
Meaning where Mr. Cook said, this is where I got shot. Okay. These may come in better through Mr. Cook because it sounds like Sergeant Campbell didn't interact with these pictures look like they are, I just got to Grady, as opposed to I've been at Grady for a day or two when Sergeant Campbell saw them. So I don't know. You can ask that Sergeant Campbell can say these are fair and accurate depictions of how Mr. Cook looked when he first got to Grady. But however you want to navigate that.
Sergeant Campbell. So when you first got to Grady, the photos that I've shown you, do they fairly and accurately depict the victim, Thomas Cook, and the condition that he was in?
These pictures, no. So when I got to Grady, he had already been treated and his injuries were covered, but where his injuries were covered are consistent with what these pictures show they would be.
All right. All right, and what else did you do to so I'll move on from the pictures.
Okay.
In the pictures in this case. What else did you do in order to determine that the defendant was the shooter in this case?
Well, so at the hospital, I interviewed Mr. Cook and just wanted to get like a basic understanding of what happened from his perspective. And Mr. Cook said that he was
could you talk about what you learned from speaking with Mr. Cook?
okay. Well, I learned that he said that he had seen the person who shot him before, but he didn't
Judge,
really know.
again, that this is hearsay. I would think that he could testify as a result of
No, you're correct. So Mr. Cook may have an opportunity to talk to us about what happened. He hasn't been impeached yet, so I don't think it's appropriate for Sergeant Campbell to do you're not doing anything wrong, but to have an end around a hearsay objection instead of saying, what did Mr. Cook say? What did you learn from Mr. Cook? Really the same thing. He learned from Mr. Cook what Mr. Cook told him, which would be the hearsay here. So if you want to ask Sergeant Campbell what he did as a result of his interview with Mr. Cook, I'm happy to hear about that.
Sergeant Campbell, what did you do as a result of your interview with the victim?
As a result of my interview with the victim, I secured arrest warrants for Roger Jones for aggravated assault with a deadly weapon and possession of a firearm during the commission of a felony.
And when you pulled your arrest warrants, did you review the defendant's criminal history?
I did.
Okay.
You mentioned something about a photo lineup. You shared the photo lineup that you prepared with Mr. Cook?
So
Or with someone different?
it was someone different.
Okay, I thought I misunderstood. I thought when you got the photo lineup together, you took it for him to see.
No, sir. No, sir. So that all happened in the same day. But when I spoke to Mr. Cook, I wanted to get an understanding of what what took place.
Mhm.
So then I prepared a 6-person lineup, and it was presented to him by another investigator.
Oh, so someone did present a photo lineup to Mr. Cook. It just, you put it together. You just, because you're the investigating officer, you don't do it. You get someone else who doesn't know anything about it to say, hey, do you recognize anyone in here? Mr. Cook does whatever he does.
Yes, sir.
Got it. You did the photo lineup after your interview with Mr. Cook.
No,
You had already done the photo lineup.
I'd done the photo lineup already.
Okay.
And I wanted to speak with Mr. Cook to see if what he had to say was consistent with what other investigators and what the video. And once I found that it was relatively consistent, then
You called upon a colleague to present the photo lineup to Mr. Cook.
yes, sir.
Got it. Okay.
Okay, and the colleague that did the photo lineup, who was that?
It was Investigator Thames,
Can you spell the last name?
EDWARDS-THA.
Oh, that was all the last name, that whole thing.
Yes, sir.
Okay.
So it's -THAMES.
Got it.
Okay, one moment, Your Honor.
Mhm. While Ms. Clark's looking at that, did you ever learn, Sergeant Campbell, what was at the end of that walkway? We see the person in black with the gun that you've identified as Mr. Jones walking away from the white car and down a walkway, which is clear from the video, that's going towards one of the units at Rolling Bends. Did you determine what unit or units of interest were that way?
Yes, sir. It was C420,
And who's at C420?
Alexis Wiggins.
Okay. And Alexis Riggins, her connection then would be her sister was the young lady we saw walking in. Okay. And it was Ms. Riggins' girlfriend of Mr. Cook or just friend of Mr. Cook? Or you don't know?
I'm not entirely sure, but Ms. Reagan said that Roderick was her sister's baby dad.
Yep. But Mr. Cook's connection to Alexis Riggins was their friends. Got it.
Okay.
Yes, ma'am. Whenever you're ready.
Okay. Sergeant Campbell, let's go back to the photographs that have been previously admitted as states 1 through 4. From your investigation, what were you able to determine from the what the defendant was holding?
Gun.
You can't see that in this picture.
And were you able to make a determination that he did in fact have a gun pointed?
Yes, ma'am. From the video.
These pictures.
I can see.
When speaking with Ms. Riggins, well, the apartment 420, who, did you learn who owned or who lived at apartment 420?
Alexis Riggins.
Yes.
And were you able to, who was visiting her?
Judge, I imagine this is going to call for hearsay.
Right. So if you know, Ms. Clark, that the way Sergeant Campbell knows the answer is someone told him, whether it's a colleague, because the colleague interviewed person X, or from an interview that Sergeant Campbell had, we need to get that person X who said, maybe it's Alexis Riggins saying, at my place was Mr. Cook.
Right.
So this isn't the conduit, as long as Ms. Hankins objects, which she's entitled to do, to get that kind of information.
Okay, I understand, Your Honor. And from the surveillance footage, were you able to determine how the defendant got there?
Yes. From the surveillance footage, it appears this white vehicle that's seen here.
And on the surveillance footage, did you see the defendant leave?
Yes.
Okay. Senator witness, Your Honor.
Ms. Hankins, questions for Sergeant Campbell?
Yes, Your Honor.
Do you want the video still up, or can Ms. Clark take that down?
No, it's been in the
Okay,
videos.
all right.
Thank you.
Okay.
I'm not.
Okay, okay, all right.
I don't know what I'll do to
Okay,
it.
okay, thank you.
Good morning, Sergeant
Hey,
Campbell.
good morning.
So you became involved in this incident the day after, in other words, March the 6th.
Yes, ma'am.
And you have testified that you have identified my client sitting at council table with me as the person in the video. Is that correct?
Yes, ma'am.
All right. And as he sits here today, he has a face mask and it comes up on the bridge of his nose. Is that right?
That's correct.
And then the face mask extends down, appears to be to his chin.
Yes, ma'am.
Okay. And the face mask extends to kind of mid cheek on either side.
Yes, ma'am.
So you cannot see the end of his nose.
That's correct.
Can't see his mouth.
That's correct.
Can't see the shape of his chin. And you can see his eyes behind a pair of glasses. All right.
That's correct.
Okay. And from that, that is the basis for your identification that he is the same person in the video?
Today, yes, ma'am.
Okay.
Did you interact with Mr. Jones at all
No,
during
sir.
the course of your investigation?
No, sir.
You saw still photos, I guess, of him because you put together the photo lineup.
Still photos and then a driver's license.
Okay, that's what I didn't mean still photos like this, but however you put together the photo lineup, you were looking at 3x5s or whatever size they were of Mr. Jones's face
Yes, sir.
with no mask on.
We don't know.
Okay.
And is it fair to say you don't know the age of the driver's license photo?
I can't recall it right now, but so, no.
So it could have been several years old.
It could have been.
And then, we've all been observing this video, which appears to be about 2 minutes and 9 seconds long. Is that fair?
That's fair.
And in a portion of that video, there is what appears to be a man. It's black. Let me rephrase that. It's a black and white video.
It's not quite, it's a strange video, but you can see like the taillights are red on, at least on my screen. Taillights are red. The gentleman in the blue box behind the black car is wearing something that looks red, but mostly, you're right, it's grays. The grass looks kind of green that the person is striding towards.
Perhaps the appropriate term is sepia. I'm not sure.
Maybe better.
But this is in fact not a full color video.
No.
And there's a person who appears to be wearing all black.
Yes.
And that is the person of interest in the video.
Yes.
And that person appears to be wearing sort of like a skull cap or a knit black hat over their hair.
Yes.
Can you make out any hair features from that video?
Not from looking at it right here.
Mhm.
Because looking at it from right here, the video is it's a little bit different from how we're able to see it.
Different in that it is more clear or less clear?
It's less clear.
Okay, but that's what we have for evidence today is
Yes,
this video, right?
Yes, ma'am.
And then, of course, there are some still shots that the state has tendered today. In your opinion, are those more or less clear?
Less clear.
And there are. Yeah. All right, so addressing states 1 through 4, do you have those in front of you right now? Okay. So in states 1, we can see, again, drawing your attention to what appears to be the hand area. It appears that.
I'm not sure which one. Are you just going through them in the order they were clipped? Because they don't have numbers on them, at least the ones I have. So states 1.
Okay, he's got a marketing. Your Honor, the state advises that if you look at the bottom, you may see a number.
Mine don't have numbers on them?
May I?
Gave you the wrong one. Mine has a little number on the bottom.
You have numbers on it? Oh, there's a handwritten. I see. Yes, it's very cute. There's this I thought you were showing me the sticker that, yes, I'm aligned now.
All right, so do we all know what states 1 is, the photograph?
Yes.
And in that photograph, there appears to be two lighter colored objects midway in the defendant's body. One of them appears to be a little lower. It looks like, is that fair to say?
I mean, like on the ground?
May I approach the witness, Judge?
You may.
I'm referring to the mid part of this person's body. There appear to be two sort of lighter colored objects right in there.
Oh, like right here. Yeah, like, okay.
Uh-huh.
Yes.
All right. Was it your assumption? What do you assume about those two lighter colored objects?
Well, one is his hand coming across his body. And then the other one would be his hand holding the gun.
Okay, and you can identify fingers?
No,
Is it fair to say these are just sort of lighter colored blobs?
they're kind of blurred. Yeah.
Okay, and then again in States Exhibit 2, addressing the same area, is that pretty much the same, a couple of areas of lighter color that you are assuming are hands,
Yes,
but there aren't real distinct characteristics.
not distinct.
Okay, and then again, in State's Exhibit 3, that's sort of a side view of that person. 3 and 4 are very similar. Would you agree?
Well, 3 and 4 are kind of different because I would say you can distinguish that he's wearing a black colored shirt and his arm is extended. And at the end of arms are normally hands. And
3 and 4 are less blurry or grainy than 1 or 2.
yes, sir.
And whoever is in all black, your theory is that it's Mr. Jones. He's now turned and we're getting a profile. You can see glasses in 3 and 4 and something in the right hand.
Yes, sir.
Okay.
Judge, I would disagree that we can see glasses. It's not clear to me. I'm not trying to be,
No, you should, I am not taking over your questioning. I just was sharing my observations as to what I can see in the photos as the fact finder. But you should ask the sergeant more questions about 3 and 4 if you want.
that's all I have of those.
Okay.
And we don't have any, as far as this video is concerned, we do not actually see this gentleman go into any apartment, right?
We can't see him go into the apartment. No, ma'am.
And we don't see him come out of an apartment door or out of
No,
the
ma'am.
apartment. We don't see him shoot anyone.
No, ma'am.
And so this was actually not the strike that. This surveillance video you've testified was just a tool in your investigation. Is that correct?
Yes, ma'am.
And the actual interviews of persons involved, you listened to in the course of your investigation, and you spoke with Mr. Cook.
Yes, ma'am.
And so that was the main source of your evidence. Is that accurate?
That's accurate.
And you've testified that the photographs of Mr. Cook in the hospital, which were states 5 through. Oh, you didn't. Okay.
You can ask about, they're not in evidence. That doesn't mean you can't ask him questions, but if he's going to talk about the contents, then you need to admit them.
No, I don't want to ask him to talk about the content.
Okay.
Get the numbers.
5 through 13.
5 through 13.
5 through 13.
So states 5 through 13, which were not admitted, you have testified that those were not.
He's got him.
Yeah. Yes, ma'am.
Those were not accurate depictions of the time that you spoke with Mr. Cook at Grady.
When I spoke with Mr. Cook, he was bandaged. So he wasn't like he was cleaned up, I should say. He had been worked on.
Right, and you testified that in states 1 through 4, the person that you identified as my client was holding a gun.
Yes.
And that is from solely from your observation of this video that we have in court today.
Not well, the video that's playing is the video that I reviewed, but it wasn't I guess in this exact medium, because the medium I reviewed it in was more clear. But I do recognize this video as being the incident location, 2500 Center Street.
And No one yet so far today has testified that through their own personal knowledge that Alexis Riggins lives at apartment 420.
No, no one has testified to that.
Thank you. That's all I have.
Ms. Clark, any redirect of Sergeant Campbell?
Yes, Your Honor. You identified, let's go back to your identification of the defendant here in the courtroom. Your Honor, for purposes, let me ask that the defendant remove his mask.
Sure. Mr. Jones, I need you to take your mask off, okay? Thank you.
So now that that the defendant has taken his mask off, do you recognize this defendant as the shooter?
I still do.
You can put it back on. Thank you.
And when you preparing your arrest warrant, were you aware that the defendant was a convicted felon?
I wasn't aware of that.
You were not.
I was not. I was not.
Your Honor, I have one moment, please.
Okay.
Okay. Where are the ones for them? Okay.
So I'm gonna, these are, so if I can, no, these are conviction records. Yes, they're
Yes,
for records. Yeah. But
For purposes of this hearing.
Your Honor, I've shown opposing counsel, but for the purposes of this hearing, wanted to show Sergeant Campbell the conviction records.
What are the exhibit numbers?
Exhibits 15, 16, 17, 18, and 19. One more.
So those come in if they're certified. This witness doesn't need to, I don't know if they're gonna be something that he necessarily relates to. I can also take judicial notice of them because I'm pretty sure they're pleas I took. For the purposes of this hearing, Ms. Hankins, any objection to exhibits 15 through 19?
No, Judge.
Okay.
Nothing further, Your Honor.
All right. May Sergeant Campbell step down?
No objection.
Ms. Clark, you're all done. Ms. Sergeant Campbell can go?
Yes, Your Honor.
Great. Thank you, sir, for being here. Appreciate it. You can leave that stuff right there. We'll let the state sort through that. All right, Ms. Clark, your next witness.
All right. The state calls Investigator Monique Edwards Thames.
yes, my name is Monique Edwards Thames. It's MONIQUE. Edwards, EDWARDS, Thames, THAMES.
All right. Before we go any further, I now do need you to take the video down so that we've got the investigator on the screen and then any exhibits you may want to put up, unless you're going to have her talk about the video.
No, Your Honor.
Okay. Thank you.
One moment, Your Honor, please. Okay. Investigator, is it Thames?
Thames like the river.
Okay, all right. What is your occupation or profession?
Yes, I am an investigator with the City of Atlanta Police Department.
Okay. And how long have you been employed?
About 14 years with the city.
And what are your present duties?
I am an investigator with the Special Victims Unit.
Were you employed in your present capacity at the time of the shooting, March 5th, 2022?
Yes, ma'am, but I was employed with the Ag Assault Unit at the time.
Ag Assault Unit, okay. So you were employed with the Ag Assault Unit. And what were your duties with the Ag Assault Unit?
Investigate any type of ag assault that come up with through investigations with those shootings, things of that nature.
And what was your role in this investigation?
I was asked by Investigator Campbell to help him show a lineup only for this case.
Okay. Your Honor, may I proceed?
You may. Thank you.
Okay. Investigator Thames, I've handed you what has been marked for purposes of identification as State's Exhibit 14. Do you recognize?
Yes, I do.
Okay. And how are you able to do so?
My name is on the paperwork as well. And I believe we went there that same day to March the 7th in the morning to do the lineup.
Okay. And when you said you went there, could you be more
I'm sorry.
specific?
I accompanied Investigator Campbell to Grady Hospital where Mr. Cook was still in the hospital.
Okay. And were you able to take a look at the photographs that I've handed you or the documents I've handed you?
Yes.
And does this packet of photos fairly and accurately depict the photo lineup that you conducted?
I believe so. Yes, ma'am.
Okay. And upon your review, have you, does it appear that any of the photographs have been altered or any deletions made?
I don't believe so. I didn't actually see each picture like that, but all I was given was a stack of pictures individually in folders and just laid them on the table.
Your Honor, the state offers Exhibit 14 for admission as evidence.
Any objection to states 14?
May I briefly voir dire?
Sure.
Investigator Thames, were the photos in black and white when they were displayed to Mr. Cook?
I can't remember. I really can't because I don't. I really can't remember if they were black and white.
Okay, and then I'm sure you're familiar with City of Atlanta policy and procedures on displaying these photographic lineups for identification.
Yeah, so usually we would read the paperwork that we're given, explain them how to look at it, And then I would usually sit them down individually in a different folder, or if they're open, just lay them out and leave the defendant. If he has a question, I'll try to ask him as best as possible on what he should do. The best way to, if he can identify anybody, and if he cannot identify anybody.
I'm sorry, complete your answer.
If he can or can't. If he can't, then that's it. There's nothing else that I can do about it. I just show the package. Whatever he shows, I give to the investigator that who was over the case.
So each photograph is contained in a separate folder, like a manila type folder?
Yes, each one what Campbell gave me was in the manila folder. And a lot of different people do it a different way, but long as they're separate from each other and you can see them individually apart, then yes.
So are they then, is the folder open and each photograph is displayed sequentially, individually?
They were just given to me in the numbers. So no numbers, they were just given out, just laid down. I didn't even open them because I don't have any idea who this person is. So I just lay each one down. So each person is different. Sometimes they have them labeled in different numbers, but some are either in order and some are not. It's laid out in front of them usually.
And so Mr. Cook would have been the one to open a particular folder?
That is correct.
Thank you. No objection.
All right, 14 is admitted.
Okay.
For purposes of this hearing, Judge.
Yes, ma'am.
Thank you.
Okay. So Investigator Thames, you conducted the photo lineup.
Yes, ma'am.
Okay. And could you just walk us through, what happened?
So I read him the paperwork that we have for the lineup, explained to him what's going on, and told him where to write his name, where it says that. And I just laid them out in front of him. Gave him a chance to say, you individually try to look at them. If there's any issue, just let me know. And he sat there. He believed he saw the person that he thought he was in the lineup. And I asked him on a scale from 1 to 100, how sure are you this person is the one? And he said he's 100% sure. And I believe he picked on here number 6.
Okay. And did you have, and number 6 is who? Who did you learn that?
From Investigator Campbell, I guess in his investigation later on, he believed it was going to be Roderick Jones that he identified.
And did you do anything to, so once the victim identified Mr. Jones as the person in the lineup, did you do anything to confirm?
I just told him where photographic lineup, where to write his name. And if he was unable or to ID him, or he was able to ID him, he said yes. He picked the number 6, and I told him where to sign his name, and I believe the date and time of this.
Okay. And let's go back to, if you could flip back to page 6, which is the document that's marked as page 6.
Mm-hmm.
Okay. And this is the picture that the defendant identified?
I believe so, yes.
Okay. And the next page is,
Mr. Thomas Cook's, right. I also have him sign on the page usually to say this is the person and put the date.
okay. So he signed the photo?
Yes,
Okay. And the photo that he signed was the defendant's photo?
that is correct, ma'am.
Okay.
Did you know at the time, Investigator Thames, which of the 6 photos Investigator Campbell was interested in?
No, I don't even know who this person is.
Okay.
Okay. Tender the witness, John.
Ms. Hankins, questions for Investigator Edwards Thames?
Thank you. Good morning, investigator.
Good morning.
I note that you asked Mr. Cook, you testified, you asked Mr. Cook, how sure are you of your identification?
Mhm.
What was your reason for asking him? that?
Usually is to make sure if that's the correct person and how sure he is of his identification. I don't want to, I guess just to make sure that we are continuing the investigation, I just have to ask that question to make sure. And he said he was 100% sure.
All right. And is that in any way relevant to the city of Atlanta procedures?
I believe so. When I was a common investigator, the supervisor always asks to make sure that their identification is good, because they're not gonna, just, I'm 50-50. You can't take out warrants on a 50-50. You have to do some more investigation. So I will make sure before we take any, are you sure this is the person that we're gonna be taking these warrants out on? So I want to make sure that we do that, because we just don't want to lock up anybody. You have to identify the person, especially if you know and seen them.
Is it fair to say that that is relevant, as you just testified, to you following up and pursuing a person in the investigation, but not as to whether he actually knows for a fact that his identification is 100%?
I'm kind of confused with your
I
question.
object, Your Honor. The question is compounded.
She's going to rephrase.
Okay.
I'm going to rephrase. What basic knowledge do you have about witness identification and the percentage of certainty, if any?
I'm not that, so I don't, the more that I do is just, when I think of it, I try to follow the procedure that we have for the department. I am not like an expert in witness, so I can't tell you something like that. I just want to make sure that this witness and this victim is able to do that. So before we move forward, unless there's more investigation. But this is not my case. So I have to just present it and ask him that question and make sure and I'll let Investigator Campbell know. And if he has to do anything more, with his case, but that's all I did.
Thank you. No further questions, ma'am.
Any redirect?
Yes, sir. Investigator Thames, is it policy? You said that this wasn't your investigation.
No, it was not.
Is it standard procedure in APD for an officer that is interested in the case to conduct the photo lineup?
Yes, they would like us to do that. Yes, it is our procedure that I have no idea who this person is, because I guess they don't want us to have some judgment, or they're like, we know, to try to give anything to say that that's the person. I don't know who he is at all.
And why do you think that policy exists?
I think it can tamper a witness's or a victim's perception, I guess, on that's the person. Or am I sure that's the person or not? So I just, we try to do that, but we have no information on the case, or try to get someone that doesn't to show the lineup, so they show that they have no bias in between.
Okay, and refer you back to page 1 of State's Exhibit 4.
4 or 14?
14, my apologies, sorry, Your Honor. And if you could read at the bottom where it says where the victim actually identified.
The witness at the bottom all the way at the end, right?
Mm-hmm.
I have identified photograph 6 as being the person who committed the crime now being investigated. I make this identification freely, voluntarily, without the threats, coercion, or promise of reward.
And did you observe the victim sign the document?
Yes, ma'am.
Okay, all right. And the victim identified the defendant as the person that did what?
Shot him, I believe, in his lower extremities.
All right, nothing further, Your Honor.
Anything else, Ms. Hankins?
No, Your Honor.
All right. Thank you, investigator, for being here. I appreciate it.
Thank you, sir.
Have a good weekend. So Ms. Clark, I'd say call your next witness, but I think you've called the two witnesses who can be here today. Is that correct? Or is there someone waiting outside?
No, Your Honor, those are the two witnesses that we have available today.
Okay. Ms. Hankins, was there any evidence you wanted to put on at this time, or you want to wait? I'm not requiring the state to rest. We'll figure out about getting Mr. Cook connected with us virtually or in person. And we'll get part two of this hearing soon. I think we need part two, based on what I've heard. Just to let you all know, the basic factual findings as they're beginning to coalesce in my mind. Sounds like Mr. Cook identified Mr. Jones as the person who shot him. We've got that, and he seemed pretty certain about it. Sergeant Campbell put a bunch of pieces together about which we didn't get to hear so much because it was mostly hearsay. And so I need to hear from either, where's my first page? Ms. Riggins or Mr. Cook, I think, to get to a better sense of what happened. The video, as you pointed out, Ms. Hankins, doesn't show the alleged incident. It shows in the sergeant's mind the alleged shooter with a gun, but just carrying a gun, that's it. And there is some graininess, as you pointed out as well. Coupled with Mr. Cook's identification, it starts to get problematic for Mr. Jones. But I think there's probably one more piece in the puzzle the state would need to place through Mr. Cook or Ms. Riggins, however they choose to do it. They plan to use Mr. Cook as the ultimate eyewitness, the alleged victim in the case, and he ended up not being available today through no shortcoming of the state's. So that's my proposal. Anything you want to get on the record concerning that proposal, Ms. Hankins?
My client wants to speak.
Sure.
2 years. I mean, I don't know when he's going to reschedule it. I mean, it could be a lot earlier, but I don't know. It could be a lot earlier than that.
Can you ask that to be as soon as possible?
Sure.
Thank you.
I'm sorry, Judge, could you repeat the question?
Yeah, I just wanted to, if you want to get anything on the record about any objections to the procedure that I'm setting, which would be that we're continuing the hearing now until we can get Mr. Cook here so that the state can call its last witness.
Well, Judge, we would just continue, object to the state continuing the case. We feel that they have failed to sustain their burden today. And today was the date set for the matter.
Okay,
I'm not saying it's any fault of the state's.
understood. I just wanted you to get that on the record. I'm going to overrule the objection. And we will set a date soon. Have you, Ms. Hankins, indicated to the state that whether you would object to remote testimony or not object?
Your Honor, we were advised that they would have no objection to remote testimony.
Okay, well, I want to hear that from Ms. Hankins. So
Oh, I'm
if
sorry.
the answer is next week, we could get everyone else here and Mr. Cook virtually, you would not object to Mr. Cook's virtual appearance in the courtroom. Is that correct?
That's correct.
Okay, it sounds like it may be in person, given the size of the bond and what Mr. Cook's mom was saying, but I will not wait to see if he can make bond. We'll figure out when everyone's schedule aligns. And I may be the main issue just because of some other things that are going on. But we will get a date set soon for part 2 of the hearing. Ms. Clark, just one more witness, because I need to let Ms. Nelson know how much time to block out. Your plan would be to call just Mr. Cook?
One moment, Your Honor.
Okay.
1 to 2, Your Honor.
Okay, at most 2.
Yes, Your Honor.
All right. So today was about an hour and 15 minutes. Do you envision it being about the same length for part 2, or should I plan for more time? We had blocked out actually all morning because you thought you'd be able to have everyone here. But another hour and a half.
Yes, Your Honor.
Okay. Ms. Hankins, are you planning on calling any witnesses other than your client potentially?
No, Your Honor.
Okay. All right. That helps me frame it. I'll get with Ms. Nelson and we will schedule part 2 of this hearing. And I guess what we'll do is get that date set, and then Ms. Clark and Mrs. Collier, you'll need to be working with Ms. Nelson as to whether we need to build a video link to Henry County or whether Mr. Cook will be coming on in. All right?
Your Honor, I needed to get since I didn't get the photos from the hospital, of the victim admitted, I'll need to get that one back.
We can do that off the record. We'll make sure you're all squared away there, but any issues with the schedule going forward?
No, Your Honor.
Okay. All right, Mr. Jones, we'll get you back in here soon.
Sure.
Yes, Ms. Hankins.
In order that I may best serve the court, if I could get an email ahead of time asking if a particular date and time I'm free and available, that would help me better serve the court.
No, yes, no doubt. That's Ms. Nelson, I think will identify a date where we've got a 2-hour block just to be safe. And then see if that works for everyone. And handle it that way. Okay.
Thank you.
All right. Thanks, everyone.
Thank you, Judge.
Thank you.
Oh, sure.
Your Honor, do we have a proceeding at 2:30?
Hold on one second. Pardon me?
Do we have a proceeding at 2:30?
Yes, ma'am. We have a suppression hearing at 2:30. Well, it's actually a Daubert hearing. So there may be all sorts of technical terms, but 2:30 today. I think it's this same Zoom call. So I'm going to leave the Zoom open. If you don't mind patching back in at about 2:25, that would be great.
Yes, thank you. I'll see you then.
Thanks so much. Officer Malou, thank you for being here. We did not end up needing you, but I appreciate your availability.
Yes, Your Honor, no problem. Have a good day.
You too. Here you go. You bet. Take care, Mr. Jones.
So all
Mr.
of
Dillon, twice in 2 days.
all of it that comes in
we don't see each
is
other.
1
And
And then, boy,
14 through 19.
the drought has ended. What do you have?
supplemental filing the case.
Okay,
Delivered a copy to the DA.
great.
I'm just stupid.
Thank you.
It was so like the initial a lot.
That it?
That's it.
Take care.
Your Honor, would you like the photos that have already been
So it's
admitted?
like-
Do we go ahead and give those to the court reporter now or wait to the very conclusion and give everything else?
Let's wait till I'll hold on to everything. I don't have the video, of course, because I don't know if that's a CD or a thumb drive, what format that's in.
And also, Your Honor, here's 1 through 4.
I've got, okay, oh, you've got the original. Yeah, why don't you give me 1 through 4,
Okay.
and then I've got 15 through 19.
And then also we need to give you 14, the
He has
original photo
14.
lineup.
He
You
has
have photo.
14. He just needs.
And I have 14. Yes, correct. So if you'll give me the originals of 1 through 4, and then we'll work out the 1A when we're back together. I'll hold on to all this because we may have a different court reporter for part 2 of the hearing, and that person can coordinate with Ms. Clay about getting her half of the transcript, but I'll hold on to this.
Thank you.
You bet. Thank you, everyone.
This is something he's supposed to do. So I'll talk to him about, how do you feel moving forward?
All right, folks should be able to hear now. Ms. Clay, are you able to hear me?
I'm able to hear you.
Great. All right, are you ready to go?
Ready.
All right. Before we bring Mr. Hodges out, I got a chat from, whoops, wrong button. A Rebecca Cooper Jackson. I don't know who that is.
Your Honor, that is my late print examiner. I spoke to Ms. Primovic. Her son tested positive for COVID yesterday. And so Ms. Primovic graciously agreed for her to testify over Zoom, so we wouldn't have to figure out another date, but she's the late print examiner.
So the screen that says APD Crime Lab is Ms. Jackson?
Yes.
Okay, that was just the there wasn't a Ms. Jackson listed under participants, but somehow I got a chat from a Ms. Jackson, and then there was something that said APD Crime Lab. That's Ms. Jackson.
Yes, Your Honor.
Okay, thank you for being gracious, Ms. Primovic.
This is cursed.
Yeah. Let's bring Mr. Hodges out, please, and we can get on the record. Ms. Ockham, I have not printed out whatever you sent. I got the email while I was at graduation. So I can pull it up on my screen. You don't need to get it to me physically, but I just wanted you to know I hadn't had a chance to read it yet.
Yes, Your Honor.
All right, we'll get on the record in 19 SC 166924. It's State versus Jerry Hodges. Mr. Hodges is here in court with his lawyer, Ms. Primovic. Hello, Mr. Hodges.
How you doing today, sir?
It's been a minute since I've seen you. You okay? Good. Mr. Hodges is here in court with Ms. Primovic. Ms. Ockham is here on behalf of the state. And we are this afternoon going to work through a motion that Ms. Primovic filed on Mr. Hodges' behalf for a Daubert hearing, which as of 21 days ago is a valid request, and that we need to have pursuant to the new, and some would say improved Rule 702, OCGA 247702, which now requires in all proceedings, not just civil proceedings, that if there's going to be a scientific expert, certain requirements are met. And specifically, as I understand it, Ms. Primovic is, I don't know if challenging is the right word, certainly requiring the state to meet its burden in connection with some fingerprint work that was done. And that is an appropriate request, and we need to work through it. I will note at the outset, before we take any testimony, that conceptually, fingerprint analysis as a technique or a method or a science, whatever word you want to apply, has been generally approved, both in Georgia courts, not necessarily applying a Daubert standard, but nonetheless in Georgia courts, and then specifically in the 11th Circuit, applying the Daubert standard. The notion of fingerprint identification has been routinely and repeatedly confirmed as a valid scientific method. We can hang what phrase we want, but it has met the 702 standard. That doesn't mean that it always does. We need to understand what happened in this case, but I'd hope that we don't have too much of a debate about, well, is fingerprint matching, and we'll use the right phraseology once our witness is testifying, I'm sure, but this idea of fingerprint identification, is it hocus pocus or is it science? And the answer may be somewhere between those two poles, but wherever the answer falls, courts have held again and again that it falls within the parameters of the Daubert standard, thus Rule 702. So I just want to share that initially so that neither side thought they needed to spend a whole lot of time about what the general state of the law is, with the final caveat, and then I promise I'll be quiet. Of course, there is zero case law in the state of Georgia about applying the new and improved Rule 702 to criminal matters. They haven't had time yet. They couldn't have brought something up on appeal, even though our Court of Appeals is fast in the 21 and a half days that the rule has been in force in its new form. With that, I believe the burden is on the state, and the state ought to go forward, but it's your motion, Ms. Primovic. Is there anything you want to get on the record before I turn to Ms. Okam and her witness?
Your Honor, nothing more that I haven't already filed.
Okay.
It's already laid the foundation.
Please turn your mic on, defense.
It may be on, it may have been turned away.
Nothing further, Your Honor, that I haven't already filed in the motion.
Okay. And Ms. Okam, you're going to go where you need to take this, but orient me. We have had a number of experts analyze these fingerprints because someone's been deployed overseas.
Yes, Your Honor.
Okay, so just before you and your witness may help establish that, but I'd ask you to just sort of map out the history of the fingerprints in this case, because this case is so different. The alleged crimes are from over a decade ago, I believe.
Yes, Your Honor.
And then Mr. Hodges was purportedly connected to them because of a fingerprint hit from 2018, 2019. The work was done, the identification with the surviving girlfriend of the deceased in Illinois or wherever it was. And here we are. So I just want to make sure I'm understanding where today's expert falls in that chain of matching fingerprints.
Yes, Your Honor. May I proceed?
Please.
Your Honor, this case was a 2007 murder that happened in Fulton County on Magnolia Way. There was a hit in 2018. So in 2007, the fingerprints were uploaded into AFIS and there were no hits. There was a hit and it became a cold case and it went through various detectives. And then Detective Zimbrick took over in 2018 and he looked over the case file again, at which point he asked the fingerprint unit to look to see if there was an AFIS hit. At that point in 2018, he got an AFIS hit. And from the AFIS hit, he did a photo array of the defendant, Mr. Hodges, but using his juvenile photo array because that's what the victim saw. And then she positively identified him. At the time, the fingerprint examiner that took the photo array was Samuel McCook. And he was the one that said that that was the defendant's fingerprint. And
So let me stop you there. First, I need you to spell the last name.
McCook is McCook and Samuel is common spelling.
And is that the gentleman who is deployed overseas?
Yes, Your Honor.
Okay. And McCook is the one who, because of an AFIS hit, confirmed it. In other words, he hears AFIS say, this may be the same person, but then he, using his skills, says, let me confirm that AFIS was right. I'm going to take whatever the exemplar was and then a print from Mr. Hodges, I guess in connection with a more recent arrest. And I, Mr. McCook, say they're the same.
Yes. So so what happens is when you get arrested, once you're arrested, APD does your fingerprints and uploads it into AFIS. And so AFIS keeps a running database of every suspect that's arrested into the system. It's not only in Fulton County, it's all the counties, and basically all of US uses the AFIS system. And so he gets uploaded. And so when he was arrested, they said it was a hit, but the fingerprint examiners cannot go off of the AFIS hit. They have to print out the AFIS file and manually get the latent print and compare it to his fingerprint file and say that it is in fact the defendant's print. After that is done, then the supervisor also has to check the work. So Mr. McCook's supervisor at the time was Raymond Lauzon, and he was the person that was supposed to testify, but he couldn't because he was on FMLA.
So McCook is deployed and Lauzon is FMLA.
Yes.
And so we couldn't go forward with the trial when we thought we were ready.
Yes, and so
Okay.
that's why I filed the motion. And
Okay.
Mr. McCook said he wasn't going to be back till December, and I realized that that was not a feasible or viable option. And so I had APD retest the fingerprint, and that's when Ms. Jackson got involved.
Okay.
So she pulled it again, his prints that he put in, and compared it to the latent print lift. And when she compared the two of them, she said that yes, in fact, it is Mr. Hodges.
Okay.
And then after she did that, her supervisor, Sandra Tallis, confirmed her test, and Tullis is spelled Tullis, and Lauzon is Lauzon. They confirm, well, not they, Ms. Tullis confirmed the fingerprint hit, and that's why we set, the states sent a supplemental report with all her new findings, because she had to do everything from scratch. And I provided that to defense as well.
Got it. So originally the green or red or whatever color light it is from APHIS goes off. McCook says, these are the same people. Lauzon says, you're right. I have reviewed it and I agree with your assessment.
Yes.
Both those gentlemen are unavailable, or at least McCook will be for a long time.
Yes, Your Honor.
So we had a redo.
Yes. Your Honor.
And Ms. Jackson is now in the role of McCook and Tullis is in the role of Lauzon.
Yes, Your Honor.
Okay, it's not a new set of prints.
No.
It is analyzing what McCook and Lauzon looked at.
Well, yes, because it's the same APHIS print that's put in the system, the defendant's same fingerprint, so it's not a different fingerprint over and over again. And the latent print obviously remains the same because it was from the 2007
Right. Okay.
Murder.
All right, that helps orient me. When you are ready to call Ms. Jackson or anyone else you want to call, we should do it.
Yes, Your Honor, the state calls Ms. Jackson. Ms. Jackson, can you hear me?
I can. Good afternoon.
Good afternoon, thank you. Your Honor, would you like to swear in? Or
I'm going to have our Deputy Gordon handle that.
Can you raise your right hand?
Wearing the retro uniform today.
Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth and nothing?
I do.
You only have to say this, spell your name for the record.
I am Rebecca Cooper Jackson.
Can you spell that, please, ma'am?
Yes, Rebecca, REBECCA, Cooper, COOPER, Jackson, JACKSON.
And ma'am, what is your current occupation?
I am a latent print examiner.
And where are you employed?
The Atlanta Police Department Crime Lab.
Okay. And how long have you been employed there?
I've been there for a year now.
Prior to the Atlanta Police Department Crime Lab, where were you employed?
I was employed at the Georgia Bureau of Investigation.
And what was your position over there?
The same, a latent print examiner.
Okay. And how long were you at the Georgia Bureau of Investigation?
About 2 years there.
And what exactly is a latent print examiner? What does that mean?
So it is a scientist who analyzes and examines fingerprints for latent prints.
How does one become a latent print examiner?
There are several avenues. Some people start out doing crime scene and evolve to latent. Myself, I went to the National Latent Print Training Academy. I also hold a degree in biological sciences from Howard University. So there are a few different avenues. Some people have on-the-job training as latent print examiners as well.
And how did you get how did you become a latent print examiner? Did you get training, on-the-job training? Can you tell us about that?
Yes, I attended the National Latent Print Training Academy. At the time, it was in Hattiesburg, Mississippi, at Camp Shelby, which is a military installation. I was there for approximately 6 months at the academy, and I finished with a diploma in latent print examination.
And approximately how many training hours did you receive there?
Over 800 training hours.
And while you were training, were you also able to work on cases?
No, it was just training during that time.
Okay. So then after the training, what other training and experience did you get?
Well, since then, I've had ongoing trainings from IAI conferences, the international.
Thank you. That's what I was about to ask you.
Yes, I'm sorry. The International Association for Identification. So I have attended those conferences. I take training there. Just as recent as this month, I trained in Grand Prairie, Texas for latents. So the training is ongoing.
And the training that's going on ongoing, who runs this training?
Typically, the International Association for Identification. I've also attended training with Ron Smith and Associates, which is a leading trainer for latents and forensics in general. And the next course I take will be by Searchy, I believe, which is also a forensic science training facility.
And how many latent prints would you say you've examined in your career?
Thousands.
And have you also had on-the-job training as well?
Yes.
And can you tell us a little bit about the on-job training that you had?
I trained to do more APHIS and ULW searches. Some of the classes that I've taken are simultaneous impressions. So that has to do with obviously a collective of impressions that are left at one time, which is typically what we see as we handle items. I've taken classes on distortion. So that involves latent prints or a hand that moves while it's touching a surface. I've also taken classes in courtroom testimony and how to explain permanence and uniqueness in fingerprinting.
And can you tell me what that means, permanence and uniqueness?
So each individual has their own specific and unique set of fingerprints. That means it's never been found that two people have the same fingerprints. It's rooted in biology. The fingerprints are developed in utero, close to 10 weeks. I think it's 10 and a half weeks. And while even twins share the same DNA, identical twins share the same DNA, twins do not share the same fingerprints. And so latent print examiners feel pretty proud that even with DNA technology, we can still tell the difference between twins.
Okay. And were you asked to compare prints in this case, 070752074?
Correct, yes.
Okay. And what methodology did you use to compare prints in this case?
I used the ACE-V methodology, which is the common fingerprint technology used by latent print examiners.
And what does ACE-V stand for?
It is an acronym for analysis, comparison, evaluation, and then verification.
Okay. And in those steps, are those the commonly used steps that every latent print examiner uses to identify a fingerprint?
Exactly.
Okay. And do you know the error rate for this methodology that you use in your profession?
There is, with using this methodology, there is zero error rate. It is simply because you are repeating the same steps independent of the first person. And so if you were to find an error, it's corrected prior to any reporting. So there's no error rate with the methodology.
Let me explore that a little bit, if I may, Ms. Jackson. Because the 0% error rate, that just caused me to sit up straight. If you examine the prints and an error creeps in and your supervisor doesn't catch it, how is it that there's not an error in the process? I mean, I appreciate that people are revisiting things and there's the value of having a supervisor review or redo the work or whatnot, but it's humans either way. And so that would be you as one human and Ms. Tallis as one human. So are you saying that not in the history of the application of ACE-V has there been an erroneous identification?
Oh, absolutely not.
Okay.
No,
I misunderstood you
not. So when you speak about an error rate, and I think it was maybe 2017 or prior to that, the last one study was done. And so when they calculated the errors, when both examiners, meaning the initial examiner and the verifier, follow the ACE-V methodology, it was 0.0025. And so it's under 0%. And so that's why it's said to have a 0% error rate. Of course, it doesn't mean that errors are never made.
Okay.
But the thought process is if two people are following the same methodology, and just so you understand, it's not just that the supervisor's checking, there's a second person who is actually going step by step. They don't start at the end. They start from the beginning and work their way through the case.
And that was my understanding. I was shorthanding it. And so it's not just simply with a red pen, check, 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 with Ms. Jackson did the right things. It's redoing your work. So the error rate is 0% by rounding, not by there's never, ever been a misidentification.
Correct.
Okay, thank you.
Okay. And so I believe I stopped at the ASB method. So at this case, were you asked to compare fingerprints?
Yes.
Okay. And walk me through the process of getting a hit and comparing fingerprints so that we're clear.
Yes. So as you stated earlier, this case came to be through a few other channels or investigators. So when I received it, I took the case from the beginning. I reviewed the lift cards that were enclosed. There were 4. In this particular case, only 2 of the 4 were what we call suitable.
What does that mean?
And so the suitability for our standard operating procedures involve analyzing each lift card and understanding that 7 minutia must be present before I can move forward with the latent prints. And so with the 4 lift cards, there were 2 lift cards that met that criteria. And so after narrowing from the 4 down to the 2, I was able to move forward and run the impressions on the APHIS database.
When you say minutia, what do you mean by that when you're talking about a print on a lift card?
So minutia are essentially the details that you would see on the friction-rich skin. Minutia could be a bifurcation. It could be an ending ridge. It could be an island. There are all the characteristics that actually make the fingerprint unique to each individual.
And you need to be able to see at least 7 for it to be a suitable print.
Correct. Our agency requires 7. Other places may say 5, but our agency requirement is 7.
And by agency, you mean Atlanta Police?
That is correct.
Did GBI have a higher or lower minutia requirement?
Theirs was lower. Theirs was 5.
Okay.
I believe you stopped at, you checked the minutia and then you found that it was suitable. And then what was your next step that you took after you found out that it was suitable to be compared?
And so I utilized the APHIS system. I input the fingerprint and one from one lift card, L1A, and then the second from the second lift card, L2. So there were the 2.
Okay, can you tell me what that L1 and L2 means? You put up your fingers, please, and show us what you're talking about.
Well, at this point, it's just the 2 separate lift cards. We just named them so that we can keep track of how many latents or impressions are on each one. And so L1 had an impression that was suitable, meaning it had the 7. L2 also had an impression that was suitable, meaning it had 7. And so I ran both into the APHIS system. And how that works.
A little bit about the APHIS system.
And so when you enter a latent print into the system, you can either do so by scanning it in, or they have a camera that's attached to it. It's basically an upload of the image. Once the image is in the APHIS system, I plot those said minutia. And by plotting, I mean the system has a kind of click and drag mode where it identifies each area. I can tell the system the pattern type. There are 3 different types of fingerprint patterns. And so I input this information into the APHIS system. And once I've completed the pattern type, the minutia, anything else that is pertinent, if it's a left hand or right hand, then I click the search button. I can search city, I can search the state, I can search both. In this case, and in most cases, we just search both the city and the state database off the bat.
And when you search the APHIS, what does APHIS stand for? I know it's an
APHIS,
acronym.
Yes, it is. It's the Automated Fingerprint Identification System.
And so when you input that into the APHIS system, what happens? Do you get a result?
You do. It is a candidate list. So essentially it's an algorithm and it matches what I've just input with, as you stated earlier, the cards that are already present in the system. And so as it's matching, it will give me a candidate list. And this particular candidate list, our agency sets it for 10, some a lot less, but we look at 10 candidates for our cases. And that is how we come to have more of a narrowed down list, if you will, of candidates to compare using that ACE-V methodology.
And so do you do the ACE-V methodology? I apologize, for the 10 candidates? How do you end up with, okay, go ahead. Explain that process to me for the 10 candidates.
Before you explain the process, APD has set their relationship with APHIS to come up with 10 candidates. Will it always produce 10, even if numbers 6 through 10 are terrible, terrible matches, but they're the closest to it? Or will you sometimes get a list of less than 10 because there are only 5 in the database that are even remotely matching the minutia that you have plotted?
So, Judge, both of those are true. Sometimes I don't get a full 10 candidates, and then sometimes I do get 10, and by the time I get to 5, you're absolutely right. They get worse and worse as you go down the list.
Okay.
So yes, I analyze each candidate as I'm going through it, but what is important to understand is that the latent that is presented as evidence is the one that I am analyzing to input into the system, meaning that is where I am marking the minutia. That is where I am entering the fingerprint pattern type and so on. And so as I receive the candidate list back, I click each one by one and do a direct side-by-side comparison. I'm obviously looking for the same minutia present in the latent as I am in the known fingerprint card that has just been produced by the APHIS system.
And when you went through the 10, were you able to come up with one a fingerprint that matched?
Yes.
And what fingerprint did you have that matched?
So in this particular one, the lift card was L2A, so it was the second lift card. And there was one single print on the lift card that was sufficient, meaning that it had the 7 minutia to search. And it was the left middle finger. So we would say, and the computer would give us number 8. It is counting the fingers. And so it showed me number 8, which is the left middle.
And what happened to the L1? Because you said there was L1 and L2 latent prints. What happened to the L1 latent print that you had?
So the L1 was also run, but it did not hit to a person. It was a non-match, or it was not identified.
Okay. And so you were not able to match that. It was the L2 print off of the latent print that was able to be matched to the defendant. And you said it was number 8, counting from the right?
Yes. So you start with your thumb as number 1. So 1 through 5 on your right hand, and then 6 through 10 on your left. So 8 is the left middle.
And what was the name of the person that you decided that you are, based on your methodology, the ACE-V method, that you decided was the print, the number 8 finger?
So it doesn't give me a name. It gives me a number that is associated with the fingerprint card. And so I use the number to retrieve the fingerprint card. And the fingerprint card was bearing the name Jerry Bernard Hodges.
Did he give you other information on the fingerprint card?
Correct.
And what was the other information you got on the fingerprint card?
It has the state identification number. So again, as I mentioned earlier, we run on both a local and a state with that APHIS search. So it gave me both the state identification number and the local city number. So it hit on two databases.
Okay, did you give you your date of birth? Did he give you his information? Can you tell us what that information is as well?
Yes, so just looking left to right at the fingerprint card, I have the state identification number S363-5811H as in Harry. Date of birth, it has it as 03/08/1991. Male, race, Black, height 5'5", weight 140, eyes brown, hair brown. And there is a social security number.
And all that, I'm sorry.
Would you have expected, Ms. Jackson, more of, I don't know what was on L2, the lift card, if there was more than one print on it? Did L2 have only one print, or was it like a hand that went on a window and so there were 4 prints on it?
So L2, I'm looking at it, it looks like there are 3 impressions and kind of similar to what you did, but more like this.
Okay. So did it concern you that only one of the 3, so number 8, which would mean if pretend 8 was in the middle, 7 and 9 didn't match Mr. Hodges?
That would concern me, only it wasn't what you just did. It was not in the middle.
Okay.
So what you said, that would be odd or concerning, but it was not like that. It was on the end.
Okay.
And it was clear. The other 2 were not viable. They were not suitable. So those 2 literally look like 2 smudges, like a lot of movement, a very heavy deposition pressure, kind of like just black, whereas the other was clear.
So you could tell that 3 fingers had contacted whatever surface these prints were lifted from, but only one of the 3 was, I'll use layman's terms, legible. The other 2 were not legible.
That's accurate.
Okay, thank you.
And based on the fingerprint card, could you tell where the latent prints were lifted off of from?
The fingerprint card stated that it was edge, the officer wrote edge of window screen.
And how sure are you, based on your experience and the methodology that you use, that the fingerprint you lifted belonged to Jerry Bernard Hodges with the information you provided to the court today?
I'm very sure.
And after you finished your methodology, did you then turn over your work?
I did. And the wonderful thing about latent prints is that the verification is built in. It's called ACE-V. And so the V is for verification. So as long as an examiner utilizes this methodology, and again, it is the standard, every single latent print is always verified. And so this was no exception.
And the verification wasn't you, Ms. Jackson, repeating the process. The verification would have been Ms. Tullis starting from the beginning and coming up with the same result as you.
That is correct. So in this particular case, because I'm the 3rd person, and I actually ran the print. I just didn't verify from early on. So Ms. Tullis simply reviewed the report that I did. She reviewed the fingerprint card that I received with the state identification number. She then did a comparison herself against the fingerprint card and rendered the same conclusion.
Okay.
So at this point, 4 people had from your department had gone through the same process, the HB method, and had still pointed that it belonged to the defendant, Jerry Bernard Hodges.
Exactly. Two of us actually ran the print and received the candidate list, went through each candidate. And then the two people who verified for us reviewed the fingerprint card to the latent print that was submitted.
Do you recall, Ms. Jackson, where on the list of 10 candidates Mr. Hodges was?
I can get that information. So on the local database, he was number 3. And then on the state, he was number 1. And so sometimes there is I don't want to say a score, but it is a numerical number. And so let's say it doesn't always necessarily have to be a high number, but it is a number nevertheless. Sometimes it can be high. The score initially back in, I don't know what year that was a 999. It also hit as a 3236. So it's like 9,000, 3,000. Mine was 5,000. So it just really depends. But the highest score that you can get is 10,000. And I think it hit at 9,999 early on.
The fact that it wasn't the number 1 on the list, does that give you pause that, wait, maybe there's a better match? I know you checked because that's how you do it. You would have done number 1, number 2, number 3. Is that different, uncommon, that the match comes further down the list than number 1? And typically the first one on the list is the match if there's going to be a match?
No, not really. It didn't give me concern. We do go through the list in its entirety until you get to the match, obviously. But no, like I said, sometimes it can hit at a number 1 in 9,900. Sometimes it can hit number 3 at 1,000. In this case, it hit number 1 on the state level, but on number 3 on the local level.
Okay.
So.
Got it.
I don't think I have any other questions for this witness at this point, Your Honor.
Ms. Primovic, questions for Ms. Jackson?
Just a few. Thank you, ma'am. When Ms. Tullis was confirming, you said that she read your report and looked at your stuff. What do you mean by that?
So I would, before I give my completed report or, submit a completed report, she has to do a verification. So what I mean is that I would have given her the temperament card. I would have given her the list of candidates that I reviewed. I would give her my analysis and she would have those items.
So she would know that you picked somebody out of those 10?
Oh, yes.
Okay. So she knows if she has to confirm something, right? Because you found somebody.
Well, not confirmed. She would be responsible for doing the analysis, the comparison, and then evaluating herself. But she would know, she would have knowledge of my findings, but she has to do the ACE part because now she is the V. She's the verification. So she has to do the analysis, comparison, and evaluation on her own.
And who does the B part? Sorry, Judge.
Before you fall, I'm sorry to interrupt, but I just want to make sure Ms. Jackson provided all of her data, as I'll call it, to Ms. Tullis. Did Ms. Tullis know that you had found a match with number 3 from that list, or she simply knew you had found a match and she made the same match? That's what I'm trying to drill down to is I appreciate you sent her the data. She better be looking at the same things you were looking at. But did she also know, by the way, I think it's number 3?
She would not know, I think it's number 3. She would know, I think that it's Jerry Hodges based on the fingerprint card. So she would look at the fingerprint card. She's doing that comparison. If she wanted to know what number on the list it hit at, then she could refer to the candidate list. But she has all the information in her possession at that time.
Oh, okay. So I think I'm understanding. You don't say, oh, and by the way, that was number 3 on the list. Not that you're trying to hide anything from Ms. Tullis, but it's different from a scenario or a process whereby you would let your supervisor know, I've made a match, but I'm not going to tell you who that match is, which one it is, because the whole point of verifying would be then let's have the supervisor go through the very same process and see if the supervisor comes up with the same match. But it's, and I may not be understanding it, but it sounds like the total that you give Ms. Tullis would include that additional piece that you matched to Hodges, as opposed to just the fact that a match was made, which is of course why you're asking for the verification. Does that make sense? That I'm just trying to understand, because to me, it's a different impact of the verification. If Ms. Tullis is saying, yeah, I got what you got, versus, well, here's what I got. And then we open the envelope and dun, 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 she got what you got. It was a blind review, if that makes sense. And I may be using all the wrong terms.
And no, you're not using the wrong terms, but I will clarify. This was not a blind review.
Okay.
There is a such thing as a blind verification, meaning Ms. Tullis would not have a candidate list, or she would not have a name, let's say, on the fingerprint card. But no, this wasn't a blind verification. And while I understand the thought or question about where the candidates lie on the list, that isn't really something that we would say, I have a hit, it hit at number 3. That's not important to us, because at the end of the day, we are actually basing the evaluation on the comparison. Mm-hmm. So if it hits at 1 or 10, it really doesn't matter as much to us. Obviously, we're looking for whether or not it's an identification.
So let me ask one more, if I may, Ms. Prunvik. I'm sorry I hijacked this. So just so I'm wrapping my mind around it, is Ms. Tullis basically, and I don't mean to make it sound like it's simple, but is she in essence looking at the 2 that you said matched and saying, I agree, but not just I agreed, she's doing the A, the C, and the E, but she is saying these 2 match? Or is Ms. Tullis going through each of the 10 on the list and confirming, verifying the V, that there is only one match on that list, and it's the one that you picked out? Does that make sense?
Yes, she is not going through the list.
Okay.
And it wouldn't be another on the list if we are saying that this is the identification, because remember, there's only one person with this unique set of fingerprints. Right. So once we agreed that I think that this is the identification, she does her own analysis, comparison, and also says that this is the identification. We don't go any further, because there would not be a possibility that a second person would exist with the same pattern of fingerprints.
So in effect, she doesn't even need the list, and she may not look at it, to your point, because where on the list doesn't matter. You found a match, what you believe is a match, in her verification. Going through all the steps you did, other than going through everyone on the list, is yes, looking at the minutia and whatnot, I, Ms. Tullis, concur, and here she did, that print A matches print B.
That is correct. She is looking at the fingerprint card. The images from the APHIS are also available to her, and I typically, as a routine, print the images along with the list that APHIS produces, but she is matching to the fingerprint card.
Okay, so it would be okay, I got it. Thank you.
Ms. Jackson, so the confirmer, the V, compares one set of fingerprints, the one you picked out, to each other. She doesn't do the other 9.
That's correct.
Okay.
And that's what V means at the GBI and the Tennessee Bureau of Investigation, the FBI. This is not unique to APD. The verifier is comparing the two things that the analyst said matched and isn't going back to the drawing board blindly, not knowing even if there is a match to see if you get the same result.
That is correct. And I just want to clarify, it may not be a confirmation. It's a verification. So just slightly different there because the second person isn't, obligated to agree with the first.
Sure.
But it is just to verify that if I utilize the same methodology, I will come up with the same conclusion.
Okay. Which is very Dalbert-like.
Do you guys ever talk about confirmation biases or anything like that? Isn't that an issue? If
It
some
is.
other human knows that, ooh, some other human matched, isn't that an issue that I'm sure you all discuss?
Yes, it absolutely could be. It's the thought of, oh, you got it, so I got it too.
Do you ever do anything in APD to not do verifications that have a confirmation bias? Do you have another step for your V?
No, we do not have another step for verification. Verification can be done at any phase of the ACE-V methodology, but at the very least, at the end, obviously, once the first analyst has completed their portion.
And you use 10 points from each, from the known and from the latent print. You found 10 points that matched, in your opinion?
Oh, no, I think the number I was saying, we have to have a minimum of 7 points to even utilize the impression.
How many points did you use to match the fingerprint in this case?
Oh, this one, let me see.
How many points from the latent matched the known?
So for L2, I have 12 bifurcations that I analyzed, so 12.
12. And you have a report with all of that showing it?
Yes. Yes,
Okay.
so a part of the analysis, we do have to document.
Okay. And you've given that to the state or will give that to the state?
Yes.
Okay.
Which is it that, Ms. Ockham, do you already have that or you will get it?
I turned it over. Is that the 12 or do you have the 10 one?
I have 10 and I can't read it.
Oh, yes, Your Honor, Ms. Primovic and I talked about it because her copy didn't print out well, and I told her that I will have my people get it to her.
But it only has 10 matches and Ms. Jackson is saying there's 12.
So there's multiple ones. There's the ones for, I gave you the whole print file because there were various people printed. So there's a Mr. Bailey, a Mr. Irvin, and Mr. Welch that were printed. So that's probably the 10.1 that it didn't match. And then there's Mr. Hodges' fingerprints, because like I said, it was a cold case and they kept running suspects through it. And so if you don't have that, it should be in her print file, her latent print file that I gave you, this one.
Okay, but we can get to Ms. Primovic, you or Ms.
Yes.
Jackson, a piece of paper or pieces of paper in which Ms. Jackson has identified the 12 matching minutia.
Yes, Your Honor.
Okay.
Ms. Jackson.
Yes.
Yes, we'll just get that over to me. I'll have my
Are the
assistant come.
pages numbered? Is it as easy as Ms. Jackson or Ms. Ockham could say, you know what, Ms. Primovic, you need to look at page 32.
Yes, Your Honor. Yes, we can.
You just don't know that page number right now.
No, I don't.
Okay.
Ms. Jackson, Your Honor is talking about the page of where you decided that it was the 12. I know you have a confused look in your face. So the page that you have that is the 12, Because your file is not that big. We'll be able to figure out what page it is and turn it over to Ms. Primovic. That's what.
Yes.
Yeah, okay. I just wanted to clear the confusion on your face.
Ms. Jackson, am I using the right terminology to say that you, if I say you matched 12 minutia between the two prints?
More or less, I understand what the discussion was now. That's why I was confused. So you'll have, I can do like a little chart so that you understand what we saw from one latent to the fingerprint card. The case notes that I was referring to was during the analysis phase, when I looked at the latent initially, how many minutia I marked clearly that I input into the APHIS system. And so, yes, there are several reports because there were so many searches done. And so each of them may have a different number to signify the hit. But I can send over, as you just stated, the information showing my analysis with the hit, the time that I did it.
Okay, and that's what we're focused on here, because you're the one who's going to be testifying. And so if McCook was 9 and you were 12, the 9 doesn't matter. What I want to understand is, did you identify 12 minutia on the lift card, but not all 12 matched to the print that is known to be Mr. Hodges, or every minutia you identified, which was 12, matched the print card?
I can't remember the number of what matched at what point on the card now. I would have to go back and look at the printout, but I don't have that now.
Okay, that's not something you can easily access from where you are with the pieces of wood on the wall.
No, I'm not
Okay.
able. I would have to go into the office
Okay.
to get back into the APHIS machine terminal for that.
What is the minimum number of matches, whatever term you'd use, to give you that level of certainty? You said you were very certain, or very sure. Your phrase was very sure of the match. How many minutia, and if I'm using the wrong term, educate me so I use the right term. How many minutia have to match from the latent card to the known print?
That's a good question, but there is no minimum number of minutia that's been discussed at the Identification Association for decades. It just doesn't work that way. It is the totality of the impression. It is how it was developed. It is what I see. It's the uniqueness. It's the sequencing. So I could not say, well, if I have 4, then I know for sure. That it just does not work that way. APHIS will allow you to search with only 4 minutia.
Okay. So you could have 6 minutia that match, but you could also see very obviously it's not the same print, because then there's this thing that is completely different. Something goes up on one of the prints, it goes down on the other. And so even though there's that nice match of 5 or 6 minutia, they're different prints.
That's exactly right. And that's why we do not give a number of, if it's this, then it must be. It just doesn't work like that.
Got it.
So the FBI doesn't have a number either?
No.
The FBI doesn't recommend a number?
Recommend or?
Recommend.
No, the Identification Association is very explicit that there is no minimum number of minutia that would qualify automatically as an identification, or that you need a certain number. Like I said, from agency to agency, and I've been at 2. One was 5, this one's 7, and I don't know much about others.
I have no further questions, Judge. Thank you.
Okay. Any redirect, Ms. Okam?
Just a couple of things, Your Honor, because she talked about sequencing, and I think that's the first time we heard what sequencing was. So can you just tell us what you mean by sequencing?
Oh, sure. The minutia. So now that we've talked about minutia, we have the bifurcations and the ending ridges. So the reason that your fingerprints are unique is because they are set in a certain sequence, and it's impossible to know that sequence because it's developed in utero. So you may have 3 bifurcations and 1 ending ridge, and then someone else may have 1 bifurcation, an ending ridge, and then an island. So they're all different sequencing. It's happenstance. You just don't know. The mother's moving. We don't know if she's a smoker. We don't know if the baby is developing quickly or slowly. We just can't predict any of this. And so the sequencing of the friction ridge development is different.
Okay, so when you say we're talking about sequencing and minutia, you are talking about, even though there are points, the sequencing of the bifurcation ridge and all of that has to also follow in sequence to the minutia as well before there could be a match. Am I explaining that correctly?
Exactly.
Okay, I don't have any other questions, Your Honor. Thank you.
Did that lead to anything for you, Ms.
Did not,
Primovic?
Your Honor. Thank you.
All right, Ms. Jackson, thank you so much for your time. I suspect you'll need to get more paperwork to Ms. Ocom so she can get it to Ms. Primovic, but she'll be in touch.
Okay.
Thank you.
Thank you.
Ms. Ocom, any other witnesses?
No, Your Honor.
Any witnesses from you, Ms. Primovic?
No, Your Honor.
All right, well, we'll close the evidence. I'm happy to hear argument if you want to make argument. I know you filed something today,
Yes.
Ms. Ocom, which I will look at. Sounds like it was some good sources in case law. I did a little homework myself just because we're now in the realm of Daubert. And that's how I was in a position to say at the outset that the fingerprint comparison work is something that has been generally accepted in Georgia, independent of the Daubert framework, because the cases I looked at were criminal cases, where Daubert didn't apply until this month. But then I looked at our friends across the aisle in the federal world and a whole bunch of 11th Circuit cases. That's how I actually heard about ACE v. There are 11th Circuit cases that say ACE v method is sufficiently reliable. But all of that, as I said, is premised on it actually having been carefully applied in the situation. So, Ms. Primovic, if, well, I don't know who starts on this. It was your motion, but it's sort of the state's burden. Why don't you start anyway, Ms. Primovic, because you raised the concern.
We had a lot of legal questions before this from the report that we didn't get, and then the state supplemented last week to help a little bit. There were a lot of unknowns that Daubert said we needed to know.
Are there still, for example, the 12, are there things that you need?
Well, I'll need that discovery.
But hearing from Ms. Jackson answered questions.
For this motion, Your Honor, it answered the 4, the admissibility of this evidence. I believe that they had shown for the admissibility of the evidence, the weight of the evidence and all of that will go to the jury. But as far as municipality is concerned, Your Honor, I believe the state has met their burden in this hearing.
When you're saying the 4, 702B has 4 factors. Those are the classic Daubert, Kumho, Tire fact. Those are the 4 you're talking about.
Correct, Your Honor.
That Ms. Jackson has the specialized knowledge. That's clear. No dispute there. Her testimony would be based upon sufficient facts or data. That seems to have been made clear. I don't think that's necessarily what you were pushing up against, although you needed to get some of the records. Her testimony would be the product of reliable principles and methods. And we heard a lot about that. And that's where I would lean on the case law I looked at, where courts have said ACE v is reliable if applied. And that's where we get to number 4. And that's what I think the crux of the testimony was. And that would be that our expert, Ms. Jackson, reliably applied the principles and methods to, it says the facts of the case, but here it would be, I'd say, the materials in the case. I agree, but we wouldn't have known that without getting this testimony in advance. And we would be too far if in the middle of trial, you were able to demonstrate that B4 hadn't been met, because presumably the state in its opening would have said, by golly, one of the reasons you ought to find Mr. Hodges guilty is this fingerprint match you're going to hear all about. Okay. Ms. Oak,
I was banking on the first lab report I got, Your Honor.
which was not the whole story.
Just
Okay.
de minimis at best.
Was that through the work Ms. Jackson did, or was that back in the McCook era?
It was from her.
Okay, it just wasn't everything.
It just wasn't everything. And then I got some more last week, but I can't read it. And then we'll have even more from this hearing. So
Sure. Okay.
is very good at getting me discovered.
I'm glad to hear that. Ms. Ocom, anything you want to add?
No, Your Honor, if the defense is conceding that we have met our burden, then I don't think I should make an argument, or unless Your Honor would like me to make an argument.
No, I
I'm
think
ready
you're
for-
wise in keeping it minimal. I'll still enter an order because a motion was filed. I concur with what Ms. Primovic has observed, and as always, she's a realist about things. I'm sure there's something at the edges, well, confirmation bias, et cetera. The response to that, though, is that's an argument for the jury and not about the reliability. It's a question about reliability, but I don't think it undercuts the admissibility of the testimony. So I will get an order entered. Ms. Primovic, I tried, I went on bended knee electronically to Judge Cox, and he has decided that a bond case that is indictment-wise older than this case, certainly not older fact-wise, needs to go first. And I've had a couple other folks confirm that. What I don't know is I don't know how he does his calendars, and if there are 4 other cases and come Monday morning, he's going to say, I actually want it to be State versus Jones and not, I think Lang is your client, State versus Lang. What is your?
Out, Your Honor.
You are, okay. I appreciate then very much that you took time today to work on this because you got to be laser focused on Mr. Lang's situation. Mr. Hodges, I had constructed the trial calendar for next week to work out in a way where your case would go. There's one case that's even older, but it ought to plead. And so yours was going to be first out. And Ms. Primovic said she's ready to go, and she was, but she has not yet mastered the art of cloning. And she will be in front of Judge Cox, trying a case that is a little bit older in terms of indictment. That could always change. It doesn't sound like it. I looked at what the state's offer is, which is basically infinity. And so I doubt Mr. Lang is going to work it out, and don't get the sense that the state is going to buckle at the last minute either. And so Ms. Primovic cannot be in my courtroom on Thursday to pick a jury. So we're going to have to defer your trial. Fortunately, not too long. I've got more trial calendars coming up. Ms. Primovic is in demand. She has cases in too many courtrooms, not her fault, but we'll figure out when we can do this. The state has worked hard to get ready on this as well. So this is not the state has dropped the ball. They're ready to go next Thursday, and Ms. Ocom could be there, but your lawyer can't. And that's who you need most of all to be in the courtroom. Hopefully Ms. Primovic has explained some of that to you. Not anyone's fault, and that's not meant to make you feel better. You have been in jail for far too long for your case to be tried. And there's a whole host of blame to spread around, and a lot of it has to do with COVID. None of it is your fault. So I will keep pressing to get one of my oldest jail cases tried. The state will remain ready. They have moved a bunch of things around to get Ms. Jackson to retest those fingerprints because things changed. Again, no fault of Mr. Hodges or Ms. Primovic's. So we'll figure it out. And I don't want you to be surprised if you get brought over on Thursday, because if on Monday morning the Lang case falls apart, Ms. Primovic knows where she needs to be on Thursday, and Ms. Ocom knows where she needs to be, and she's lined up to get people from out of town in here. I will let everyone but Ms. Primovic know if Ms. Primovic is going forward, so you can stand down the cavalry, Ms. Ocom, and then poor Mr. Thomas, who's got the 4 cases behind for which he has offered misdemeanor probation, and no one will take it. He'll need to be ready. And that's what he gets paid to do. Hopefully he comes back from Jekyll. And we'll figure all that out. And I'm sorry, Ms. Clay, you didn't need to take all that stuff down. You can stop making a record. I should have told you that once we thanked Ms. Jackson for her time. But I'm gonna have to ask the state and Ms. Jackson, others to hang loose until 10 a.m. on Monday, whenever I hear, no, they started picking the jury. If they start picking the jury, it's not the kind of thing where if Mr. Lang pleads Tuesday morning, we'll make this go. Because then Ms. Primovic's not gonna have time to get ready. So I will cut everyone loose if jury selection starts on Monday in Lang. But if something changes and there is no jury selection on Monday, then I'll also let everyone know that, and Mr. Thomas can take a deep exhale, and we will move forward with Mr. Hodges' case.
Yes, Your Honor. I appreciate that, Your Honor, because I'm flying people from out of town, so I don't want to fly them and.
No, I understand that. So I'm worried for you on that. I'm worried for Ms. Primovic in that all weekend she's going to be Lang, and then if that doesn't go, she's going to have to pivot. But that's what she's good at. So we'll figure it out. We are unfortunately beholden to another co-equal judge, and he co-equaled me on this one. So here we are. Anything else, Ms. Primovic, on behalf of Mr. Hodges?
No, Your Honor, thank you.
All right, Ms. Ocum, on behalf of the state?
No, Your Honor. Thank you. Thank you, Ms.
All right.
Jackson.